So good afternoon, everyone. Welcome to the Simple Real Estate group meeting. We have Jimmy, Charlie, Binta, and Mark here, and Yanni, I think, coming in. And Jimmy, I'm going to turn it over to you so you can introduce your attorney friend.
Awesome. Hey guys, welcome to have you guys here. For those who are listening in or tuning in later and hearing the recording, hope we can solve or answer any questions you may have. For Tyson, we're not, this is no plan or trying to tie you up to answer any questions you can't. This is just super simple, real basic on utilizing like LLCs and corporations for different real estate projects such as fix and flips or buy and holds. So Tyson, welcome. I really appreciate your time. Hopefully we can just utilize you for about 20 minutes to 30 minutes. Our show goes to about an hour, but I understand if you got to get going, just let us know. So
Sure.
we're not taking too much of your time. Can you give us a little background, a little bit on just so that way for marketing purposes for you and Anderson, get it out of the way, who you are and who you're working with, and we'll start off with that.
Yeah, sure thing. So my name's Tyson Wade. I'm one of the attorneys here at Anderson Business Advisors. We offer asset protection services and education, as well as planning for tax mitigation, estate planning. We have our fingers in quite a few different pies here, but yeah, our bread and butter is asset protection and tax mitigation with regards to specifically real estate investors and small business owners. So I'm happy to be here, happy to be able to talk about LLCs and answer your questions.
Okay, great. Appreciate it. Again, thanks for your time. So let's just start off by, I know we can Google's everywhere, but with just LLCs and corporations, just getting into real estate, if we're looking at flipping a property, I know everyone's situation is different, but if we're looking at flipping a property, what entity would suit best, or if you have any other additional information on that?
Sure, yeah. So flipping, as far as the income that you get from flipping, it's a little bit different than the income that you get from just the standard rental. Specifically, if you hold a rental, that income is going to be tagged as passive income for tax purposes. Whereas on the other hand, if you're flipping, that's going to be tagged as active income. So the income that you make from that will be it's subject to self-employment taxes in addition to ordinary income taxes. And there's a risk that if you do it a lot and you're doing it in your own name, then the IRS might tag you as what's called a dealer. So like you're selling cars, they consider these as inventory, so they may levy additional taxes on you. So as far as structuring for flip, one of the strategies that we like to employ is to use a corporation for sort of like your base. That's your base, your holding company is going to be a corporation, a C corporation, or an LLC that's taxed as a C corporation. And then that'll be sort of the operations business. If you're operating out of a C corp, you're far less likely to be tagged as what the IRS calls as a dealer, so it prevents that. But also the C corp and the S corp, they are both more beneficial at handling that self-employment tax that this active income will be subject to. So when you're doing a flip, we recommend starting with this base C Corp. And then for each flip that you do, you would set up a separate LLC that's just taxed as a disregarded entity and that is owned by this C Corp, this base C Corp that you set up. And the purpose of this LLC is to hold title to that flip. So you're separating out the liability. So if something happens during the course of the flip, you have a worker that falls off a ladder and wants to sue the property owner. The liability will be contained within that LLC, and your C Corp won't be implicated in any sort of a lawsuit or anything like that. So that's one of the reasons. Another reason for this two-step structure is you have the property that's held directly in this LLC that's owned by the C Corp. You do the flip, you sell the property, and then you're able to dissolve that LLC. And then for your next flip, you set up a new LLC, hold that new flip in that LLC, then just continue that process. And by doing that, if you you have a buyer down the road that they get a wild hair and they want to come after you, and a few months after the sale, they realize that maybe something wasn't how they thought, or maybe they had a misunderstanding, or who knows, it's unpredictable, and they want to come after you. That LLC that held title to the property is no longer in existence. So they don't really have any legal recourse there. There's no entity for them to come back and sue. So you're protected in that way. So yeah, C Corp for flipping, we generally will recommend that parent holding C Corp, and then it will own this LLC that then gets dissolved, and then you set up a new LLC that after the sale it gets dissolved. Of course, this isn't like a one-size-fits-all approach. Setting up LLCs and then dissolving them repeatedly can get expensive. So again, it's up to the individual person, sort of your risk aversion, and sort of your cost benefit analysis there.
Tyson, question. Does
Sure.
it matter where you're set for tax purposes? Does it matter where you create your C Corp? And also, if the property is in New Orleans, do you set up the LLC for where the property is residing? But then the C Corp could be in a different state or something. Can you talk about that a little bit?
Yeah, that's a great question. So the C Corp itself there won't be a particular state where it would need to be registered to do business in, just because it's just serving for holding purposes. Holding companies they're not technically doing business in any state. With this structure, it would be those LLCs that would need to be filed in particular states. So if the property itself is going to be in New Orleans, then you would need to set up a Louisiana LLC that's owned by this C Corp. As far as using holding entities, we like going through Wyoming. Wyoming's a great state. They offer fantastic protections with regard to their business entities. They also provide anonymity, and so whenever you're filing an entity within the state of Wyoming, they don't even collect ownership information. So if you're holding your business in this way, you have like a C Corp that was formed in Wyoming, and then a Louisiana LLC, then that would be sufficient for your asset protection purposes. For tax purposes, it wouldn't really matter all that much. But as far as asset protection, that would probably be ideal, to have your C Corp in Wyoming, and then for each property that you're doing a flip, you would have a state-specific LLC that would be filed in the same state where the property is located.
So for tax purposes, the LLC, you have to pay the taxes. Like if you create the Louisiana LLC, then the tax you will pay based on Louisiana taxes, right? How does that work?
No, so Well, I guess I should clarify that. So the income, as far as the money flow, the way that the income will flow in this type of structure. So say you have the Louisiana LLC, you flip the property, you get proceeds, the proceeds are paid to that Louisiana LLC. Because that Louisiana LLC is taxed as a disregarded entity, it does not file its own tax return. That LLC will not file its own tax return. Instead, the income will be reported on the first available taxpayer in this structure. And so there are essentially three taxpayers, two in this structure. There would be the C Corp. The C Corp will pay it or file its own tax return. And then you as an individual will file your own personal return. So the income will be reported on the C Corp tax return. And then if you pay yourself like a salary or a distribution out of the C Corp, then that will be reported on your personal return. So in a way, if you are a Louisiana resident, then yeah, you'll be paying, you'll be subject to taxes relevant to Louisiana. But for the C Corp itself, because it would be, filed in Wyoming, it would be paying, if it's just the C Corp itself, C Corps are subject to like a flat tax rate. I think it's 20 point something percent. Mm-hmm. And that's just at the federal level. So the C Corp isn't like us where it pays, state specific taxes. It's more just that federal flat corporate tax rate.
So you're saying that if we're not paying, let's say we create the LLC within the C Corp for Louisiana, and then we flip. So basically the job is done, the income will go up to the C Corp, but the LLC, you can basically discard the LLC, you can close the LLC. So the taxes will be the Wyoming state tax or the C Corp tax of 20 somewhat percent if we're not paying ourselves, right?
Right. Well, so if you do pay yourself, then the C Corp it'll file a return regardless, regardless of whether you pay yourself or not. If you, do or you don't, the C Corp is going to file its tax return for the income that it's received. And then for you, if you pay yourself from that C Corp, then you will file your personal taxes as a Louisiana resident or whatever state you reside in.
Yeah, got it.
But yeah, as far as the LLC goes, the Louisiana LLC, it will not file its own tax return, so you won't need to worry about anything like that as you're setting these up and then dissolving them, so on and so forth.
Now, what about having multiple people in the LLC, like 10 people?
Mm-hmm. Yeah. So for something like that, you wouldn't want all of those owners to be in, as if this is going to be like a recurring business where all of you are going to be, partnering up to continuously do flips, then it would probably be better to just have, all of you own or be shareholders in the owning C Corp. And then that way the C Corp is owning each of these individual LLCs that are operating directly holding these flips. That way you're not, it's just a lot less maintenance to have to, set up a new LLC with 10 members, and then you have to get all 10 members to sign off on the dissolution of the LLC. And then set up a new LLC with all 10 members and then have all 10 members sign off on a dissolution. It's a lot less overhead and maintenance and stuff like that if you were to do it that way.
Would that be sorry about that.
Sorry, go ahead.
Would that be like a power of attorney of like a representative?
For signing, for what exactly?
For like signing the docs, for if based on the board of super,
I see.
board, like the board
I see what you're
members
saying.
approve?
Yeah. So it would be, it depends on the business structure. If it's an LLC, then it's, you can appoint a manager that can sign documents on behalf of the entities. So it wouldn't require, the members to sign off on like a purchase agreement. But as far as the entity maintenance itself, something that regards the entity itself, especially something as big as dissolving the entity, usually requires the affirmative vote of at least a majority of the members, if not all of them. And so there'd have to be like a special meeting minutes prepared, a resolution to that end. Just additional paperwork that could get a little bit cumbersome. So to simplify it, and we like to make things simple where we can, it would be best to have everyone just own that C Corp, and then just do the flip side of that, the C Corp owning the separate LLCs. But I will say one big caveat. Whenever you're engaging in a business that regards real estate, and there are going to be multiple people that are going to be engaging in this, that are going to be owning this, there is a potential that this could fall under SEC regulations, just because if there are individuals that are relying on other individuals for the successful outcome of this business that they've bought into, it looks a lot like a syndication. Even though it might not be on the grand scale of going out and buying a several hundred unit apartment complex, the SEC might see it the same way. And so I'd be very careful in structuring these. I'd even recommend, maybe running it by an SEC attorney just to make sure that this isn't going to implicate any SEC regulations. At Anderson, we don't necessarily dabble in SEC territory. We usually don't like to set up entities that will have more than 4 members just because of that very reason. The SEC, they might look at that and, they may think that this is something that falls under SEC guidelines, which would require you to have to, jump through the various hoops that the SEC has in play, or, work with an SEC attorney to be able to put together the proper paperwork so that it doesn't fall into those SEC regulations. So I'd just be very careful if you're operating an entity with that much ownership, just because one way that people are able to get around that is they have 4 or less members, and they can each of those members each have a substantial role within the company, and that's more than just raising funds or just bringing money to the table. They have actual managerial, operational roles. But the more membership that you build, the more difficult it is to be able to substantiate, all of those people having substantial operational roles. And at that point, that's when the SEC, a red flag will raise, and they'll start thinking, hey, you know what? There's some people here that are a little bit more passive, that might be relying on these other people for the successful outcome of this business. So that's one thing to look out for.
Yeah, Tyson, for clarification. So you're talking about the active versus passive participation, where when you have 10 people and really only 2 or 3 people are actively doing the work, and the rest are just there as part of the group member, then it could be seen as syndication, that they're there passively, mostly for funding or advice or whatever it is. Right? Is that what you're saying?
Yep.
This is the...
Yeah. Yep. Yep, that's correct.
Would that be true for both the LLC and the C corporation? What you're talking about?
Yeah, so it would be just the whole structure in general. They would look at it as a whole. When you're looking at a typical syndication structure, those also look a little bit different. You can have an LLC with multiple members, or you can have what's called a limited partnership, where you have the handful of people that are actual operational, the general partners, and then you have the limited partners, which are passive. But ultimately, with the partnership, with the standard syndication, they will have that entity that is the syndicated entity that all the members own, and then that syndicated entity will own, separate LLCs that will directly hold title to the property. So that structure looks exactly like this flipping structure, where you have this entity that's owned by the members, and then you have, the separate the liability for the LLC that's just holding title to the property. So, yeah.
Yeah, you could see that. Even for the tax structure, passive versus active is different too.
Mm-hmm. Yep.
So another question was brought up too, is like, if we come across a property and we want to, let's just say flip it. And then the term kind of came around of like a shelf or like a trash can, C Corp, something that we can get on the bookshelf, of a quick one that we can just utilize just for the flipping purposes. Is that a possibility?
So that would be with regards to the LLC that would hold title to the property. You'd want to have your C Corp set up beforehand. But then, as you come across the property, you can have this self LLC set up, and you can, just have just a standard name. So it's already set up. The name isn't anything associated with the property at all. And then, that way, whenever you find a property, you can go ahead and close on it in the name of the LLC if possible, because you already have it set up. You're not having to worry about, buying the property, getting the LLC set up, and transferring the property into the LLC, having to take those extra steps. So yeah, it could be beneficial to have that self LLC ready to go.
Well, if I have a corporation, or anyone else has a corporation already, and then a property comes available, are we able to have a disregarded LLC for the flip? Meaning like another LLC that's owned by the corporation, and that's where we can flip the property in?
Yeah. Before you say you're on the market, you're looking for a property, you already have your C Corp set up. You already have your members set up. Everyone knows what they're doing within that company.
Mm-hmm.
And then, you're looking in Louisiana, but you haven't found a property yet. So you can set up this self LLC in Louisiana that's already owned by the C Corp. So it's already structurally ready to go. It just doesn't have a property in it yet. And then, once you find a property, you already have the LLC ready to go. So you can just close on the property in the LLC, and it's already in there.
So Tyson, if would it, like, if, let's say that because of all the complexity that you're talking about, if we have an outside agreement among the group members, a separate agreement outside, so Jimmy already has the C Corp. Yes, he already has the C Corp. And then we'll set up an LLC for this property attached to his C Corp. But then, as far as all these 10 people will have an outside agreement, that's not cool, huh, for audit purposes? Or how does that work?
Yeah, that wouldn't be ideal it could be done that way, but it might be messy, and the messier it is, the more likely that, something goes wrong, and, a lawsuit could ensue, and you try to avoid that. So it's always cleaner if everybody's on the owning entity, if you're planning on doing this, on a recurring basis. If not, then you all could certainly, Jimmy has a C Corp. You could enter into what's called a joint venture agreement with each of the various members. So he would join in this agreement on behalf of his C Corp, and then everybody else, they could join into this joint venture agreement, if they have their own C Corp or entities or in their own name, however they want to do that. For tax purposes, it might be better if they're operating out of a C corp or an S corp. But yeah, if you're testing the waters and you're not sure that you all want to, actually own a business entity together and do this on a recurring basis, then it might be, more beneficial to start off with this agreement, to do maybe like a one flip. And in the agreement, you state who the parties are, how the proceeds are going to be distributed and split up, and who's doing what, who has what roles, and all that. And then if it works out, then maybe you guys do want to set up an entity and then co-own that, and then just replicate this business over and over again. Mm-hmm. So you certainly can with an agreement. I would just not make it a regular occurrence. If it works out, if that makes sense.
So what
How is this different from just setting up a corporation and having all of these different parties be shareholders in the corporation? How is this different?
So how is the joint venture agreement different than that?
Yeah.
So the joint venture agreement is just a contractual agreement. There's no business entity that you all are going to own. It's just, maybe, for example, Jimmy has this C corp, and then, maybe he alone sets up this LLC to hold the property. But all of you are, you're all participating in the business by way of this agreement. So Jimmy will engage in this agreement on behalf of his C corp, and then everybody else would engage on their own behalf. So there's not a legal ownership that's combining all of you. This is contract. And then once the deal is done and the terms of this contract are done, then the contract's done. There's no more legal relationship binding you two together. There's no more legal obligations binding the parties together. It's done. Whereas on the other hand, if you are all shareholders in a corporation, once the deal is done, you're still legally bound together because this corporation is still continuing on. It's just that owner, that LLC that owned the property might get dissolved, but the underlying C corp that's operating the business is still continuing on. So it's a perpetual existence, whereas the JV is sort of a one and done.
Unless we dissolve it.
Correct.
Arlene, in the beginning,
Yeah.
in the beginning, Tyson was saying that could be done, except because our responsibility is not equal, that only 2 or 3 people are active, like really putting in the work, Charlie, Jimmy, whoever. But those are the majority. The rest of us are here, and maybe we put in some funding, but that could be looked at as syndication, meaning that we're passively participating. We're not active in the sense that they are really doing the work, and here we are gaining the benefits. So that's what I think, Tyson, correct me if I'm wrong, that it could be looked at by the FCC. That's more like a syndication deal as opposed to an equal share where you each of us here is doing, the work.
Mm-hmm. Yep.
Mark,
That's
I
right.
believe you had a question.
Mark, go ahead.
Oh, actually, it's me. Actually, Tyson, knowing now our situation, what will be your recommendation of what we have here as a group moving forward?
So if I'm understanding correctly, are all 10 of you engaging in flips together in Louisiana? Is that right?
Yes.
Okay. In that case, if you haven't done a flip
or buy and hold.
or buying, okay.
Right.
So those structures might look a little bit different, just because buy and holds have different types of income that come through to it.
Mm-hmm.
It's more passive, but if you have not already done a deal together, I would strongly recommend starting out just using a joint venture agreement. If each of you have your own business entities, I would maybe recommend entering into this joint venture agreement on behalf of your entity, and then doing a deal, seeing how it works, seeing how you all drive together, and making sure that there's a lot of synergy going on between the parties, because a partnership can be a big deal. Once you engage in business together, specifically you're co-owning a business together, then there are some doors that open up as far as the potential for a lawsuit. Whereas a JV agreement, if that one deal goes wrong, then yeah, you can sue on the contract. But if that deal goes well and the contract's done, then liability is over. You no longer have a legal obligation to other people. If you do set up the corporation and you're together, and the deal is done, and then down the road something else happens, and then you can engage in a lawsuit against other shareholders, against maybe the officers of the or directors of the C Corp. So I would first, for all of you, maybe recommend just doing a one and done joint venture agreement deal. If it works out, for those of you that want to continue forward, you feel like there's synergy, then I would strongly recommend for the fix and flip scenario, I would recommend. I would strongly suggest meeting with an SEC attorney to go over this structure. But for the flip side, I recommend the same structure: a C Corp owned by all of you. You're all shareholders, and then as you're doing these flips, you have the LLC that gets dissolved and so on and so forth. But I would for sure run this structure by an SEC attorney. He or she may want to make revisions to your operating agreement, so that it does comply with SEC regulations if needed, or maybe after you run it by him and he takes a look, or he or she, sorry, I keep saying he, but they, after the SEC attorney takes a look at your specific scenario, maybe they determine that there are no SEC regulations that play in your specific scenario. Again, we don't really have SEC attorneys here. We don't like to flirt with that line, just because there can be some severe penalties at play if you're operating in a business that could be regulated by the SEC, but you're skirting around it. So we just like to stay away from that altogether. And then for buy and hold, it looked a little bit different in that you can't necessarily do a joint venture agreement for a buy and hold, because it's going to be ideally a long-term relationship. And that would sort of be contrary to the point of a joint venture agreement, which is, relatively shorter, and then sort of like a one and done, and then you don't have any more relations with, that individual. Buy and hold, ideally you're going to be in it for several years. And so in this instance, I'd recommend you get into it with people that that you have synergy with, and I would also make sure that in your operating agreements that there are very clear buyout provisions, transferability provisions, things like that. So if one of you, heaven forbid, passes away, or decides you don't want to have anything to do with the business anymore and you just want to pass out, then the instructions in the operating agreement are clear, and everybody knows what to expect. Because when there's a change in ownership, or somebody doesn't want to be an owner anymore, or something happens, it causes change within the organization. That's usually when disputes arise. And so the clearer you can be in that regard, the better. As far as the overall structure goes, there are a few different ways that we set up buy and hold structures, depending on the circumstances. Generally speaking, though, we still like the use of a Wyoming entity to serve as that holding company, again, for the anonymity, and because they have they offer tremendous protections for their business entities. And then for each buy and hold property that you own, this Wyoming holding entity, LLC, will own a state-specific LLC, which will hold title to that property. So the difference between the flipping structure and the buy and hold structure is the tax status of that Wyoming holding entity. For C Corp, we like the use of a C Corp, for flips, we like the use of a C Corp because that income is going to be active, and C Corp and S Corp are more advantageous for dealing with active income. For long-term buy and hold, the income from that will be considered passive income, subject to passive losses. And so for those, we like to be as disregarded as we can. We like to throw in the C Corp as the S Corp because those two entities will end up, making you pay more in taxes than necessary. And so we would have the LLC that directly owns the property. Say you own a rental in Louisiana. That LLC would be disregarded, and it would be owned by a Wyoming holding entity that could be taxed disregarded if it's owned by one person, or taxed as a partnership if owned by two or more people. And then that holding entity would just be owned by you individually. So as far as taxes go for the buy and hold structure, there would really only be one tax return, and that would be your own. I will say the Wyoming holding entity, if there are two or more owners of that, and it's taxed as a partnership, it will need to file, a 1065, which is a partnership return, which is meant to produce K1, which the K1 is more, it's like an informational document that you use on your personal return. So essentially the purpose of the K1, which is produced from the 1065, is so that you're able to put on your personal return what your specific ownership percentage portion of the income and expenses and losses and all that are. So the taxation is a little more simple with the buy and hold strategy, but it's meant to take advantage of the passive income.
Mhm. Okay. I think this is something we need to discuss, Jimmy, and everyone, regarding the pros and cons, and depending on our intention.
So it pretty much sums it up, just kind of like a walkthrough of what he discussed, which is a C Corp, flipping into a utilize C Corp to flip, and then all the legal or logistics that goes in with that. And then holding a property would be an LLC, disregarded to a holding company, another LLC just for anonymity. And then also someone had asked a question which would encircle pretty much all of this, and that would be utilizing a trust. Now, can you explain like how a trust would be incorporated in all this? And would this just go over just the property? Would it be just a land trust? Or
I wouldn't. I don't think, I mean, for individual, you do the trust, but not for this. This is not a trust. I don't think.
So it would depend on the type of trust. I think I tend to agree. Probably the most beneficial trust in these structures would just be your own individual living trust for estate plan.
Yeah.
It wouldn't really have any asset
No,
protection,
not this.
implications, but it would just protect your ownership in the event that you pass away. It would, make it so that your ownership is able to be transferred to your beneficiaries, or they're at least able to receive compensation for your ownership without having to go through probate. That's the whole purpose of a living trust. Or with a land trust, so you could throw the land trust in there as well. It would just add an additional layer to the structure. I would particularly, if you did want to use a land trust, I would not recommend using that for the fix and flip strategy. I'd just use that for the buy and hold strategy.
right.
But with that being said, it really isn't. It's not a necessity. It'll add an additional layer of anonymity. But again, you already have that a level of anonymity by using that Wyoming holding entity.
Yeah.
So it might not be, the bang might not be worth the buck on that front. There's another form of trust, sort of like a business trust. If you were to engage in, if you met with say for example, you meet with an SEC attorney and they determine that, this type of, this sort of business venture might involve SEC regulations, then one thing that you could do is set up a Delaware statutory trust, and it would look a lot like the holding structure. It wouldn't be taxed as a C corp. It would sort of flow through to the owners, and then each owner would own their interest in this Delaware statutory trust with their own C corp. Well, I guess, let me backtrack. I would only use the Delaware statutory trust in the buy and hold. So, I wouldn't recommend actually incorporating a C corp into that at all. But the Delaware statutory trust, we don't actually set them up at Anderson.
We'd have to get off.
But if you did want to use one, I will say the benefit in using it is each member can have the opportunity to sell their individual interest in 1031, exchange their interest into another property that they want to acquire. Whereas if you all are engaging in this buy and hold structure and you each just own part of the Wyoming holding entity, then that's not an option. You either will all need to agree to 1031 the property out of the holding or out of the property LLC, or that person will just need to sell their ownership interest.
Yeah, it sounds to me like the trust is really like you're talking about like tenant in common, and then you can do 1031 in the future if you decide. Yeah, I don't think this is the
right
to use that. Yeah.
What is the upper number of members before you think the SEC gets triggered? Basically, it's like you mentioned 4, right?
Yeah, and it's not a hard number. We just, the more members, the more blurry the line is, and so just here at Anderson specifically, we just have a policy of 4 members is the most we'll do without looking at it very, very, very closely.
Right.
I think Jimmy, where are you? Do you have any other questions? Tyson, this has been so valuable and great conversation. Thank you so much.
Yeah, thanks,
Happy
Tyson.
to be here. Happy to help.
I appreciate it. Does anybody have any additional questions?
I just wanted to, so that I am clear. So with this structure, the idea of having the partnership is that there's little or no liability, because at the close of the day, we close out the partnership. And so there really is no mutual opportunity for suits. But if we had a company where we all were part owners, like we had shares like any regular company, sometimes it's 20 people, it's 30 people, it could be 100 people that have shares in this particular entity, then the reason why we wouldn't want to do that type is because then that opens us up to liability, because then you're saying we actually own something.
Right, and that's only, I would only advise against setting up the entity together if you're just planning on doing one deal and being done. If this is going to be a recurring business, then it would be better to just to set up an entity and co-own that entity. Otherwise, you're going to be setting up a joint venture agreement for each and every deal that you do, which, in my opinion and in my experience from what I've seen in a past life where I was a litigator, the more each of those are separate business engagements. Each separate business engagement that you engage in is an additional opportunity for liability. So just because there's going to be, maybe on one deal, you need to have certain roles. And then on the next deal, maybe one of the roles changes a little bit. And then, just these little tweaks to each deal can cause some rub that could result in a litigation. Whereas on the other hand, if you are going to be, doing deals over and over again, and you are engaged in, and you all own a common business entity that you're working out of, then that sort of helps solidify the roles. The process has become, you can systematize it so that it's everything is just on repeat. The roles are the same, ownership percentages are the same, distributions are the same. Everything is just the same across the board, so it makes it more simple. Not to say that it can't be done using joint venture agreements where you just the terms are the same each and every business opportunity that you have. I'll just say that in my experience, those tend to breed more lawsuits.
Okay, so example, I'm a part of JP Morgan Chase. I have a little piece of a share. The board of directors, they make decisions all the time. They make purchases, they make sales, they do whatever they do. Technically, I am a part of it, but they don't consult me before they can, move forward. And I don't feel like I'm more liable to lawsuits, even though I am a small shareholder in that whole organization. So how is this different from that, so I can see it? Because in my brain, I'm like, oh, well, this is the same thing. The board of directors, the key people who are making these decisions, the 3 or 4 people, they're the key people, but the other shareholders are just the people who are, supporting CAST in whatever way that we are. How is this different, so that I can understand the difference? Because obviously that looks simple to me, because they don't have to wait on us to make the decisions. I'm not at fear of any lawsuits, but I do have a part ownership in that company and several others, but I don't impact. It does impact me in the long run, but not in terms of the day-to-day. So tell me how it's different.
Right. Yeah. So the traditional, you own shares in a big company, though they are subject to SEC guidelines. You are a passive investor, and you're relying on others, the board of directors, solely for the success of the business. And so it is almost exactly like, look, if you were to work with the syndication, an apartment syndication where you are just a passive investor, you give them funds, you buy, quote unquote, a share in that business entity, and then the general partners go out, they do all the work, and then they pay you distribution. So it is the same. Those things are the same. Your business venture, if you're trying to avoid SEC regulations, it would be different in that you would need to be more actively engaged. You would need to have an operational role, so that you're not having to be governed by SEC guidelines. Not saying that being governed by SEC guidelines is the worst. Obviously, all of these big companies that you own stocks in, they're governed by SEC guidelines. It's more expensive that way, because you'll have to, again, you'll need to retain an SEC attorney. There's a bunch of additional paperwork and red tape and all that kind of jazz. So, yeah, did that answer your question?
Yes, it did. Thank you for answering the follow-up question. So they're subject to the SEC guidelines if we want to be subject. Okay, got it.
Yep. Unless anybody have any other questions, just want to, before we send Tyson off.
Thank you so much, Tyson. This is very helpful. Really appreciate it.
Absolutely. Yeah, glad to help.
Thanks.
Anybody? Mark?
Just thank you.
Well, I got a million questions, but they're not going to be answered right now.
I'm gonna keep him here until tomorrow.
Thank you so
Yanni
much,
or
Tyson.
Steph?
Sounds like just a partnership. not a company.
And I can help answer some of those questions too, because of my background and experience of being a part of some of those. But first and foremost, thanks, Tyson. I appreciate your time. We really value you and all the information you provided for us. So thank you so much. If you could tell Shayna that Jimmy Gonzales says hi, I'm sure she'd be happy.
Will do. Yep, I sure will.
Awesome.
Thank
Thank
you.
you again.
Thank
Bye-bye.
you.
All right, Tyson. Thank you.
Absolutely.
All right, bye.
Bye.
Thanks. Bye.
All right, so
Yeah, so basically it's just the fact that whether you're active or passive, the treatment is different as far as FCC is concerned. Whether you're just like, because then it's looked at as a syndication rather than the full that you're a shareholder of a C corp. That's really it.
Yeah.
They call it tenant in common in that particular case.
Mm-hmm.
Say it again?
Tenant in common. You just own a small portion of the share, but you're passively, you're not active. You're passive
Right.
participant in that. So the tax treatment is totally different with that too.
So
You have very limited liability because your participation is really funding or something, but it's very small. You're not active. Go ahead, Mark.
no, I mean it sounds like the only way would be to have like two of those, kind of split it up almost, to not have that problem appear.
Mm-hmm.
wow. You mean split it in half?
Like we could have two of those C corps, basically, that would avoid the SEC involvement.
Oh, that's an
Oh.
awesome idea. Thinking
Well,
outside the
I'm
box,
thinking-
Mark.
I'm just that's what it looks like for it to
No.
work without having all the problems.
Yeah, no.
That was
I think the easiest would
two
be
separate
to piggyback.
companies.
Yeah, I think the simplest in the beginning is to piggyback on Jimmy's C Corp and create an LLC, a trash LLC for this particular project and see how we decide to move forward.
Yeah.
Right. Like, so if we were to wholesale or flip, we can just all just do a JV agreement, or we can open up an LLC, just like he mentioned, under my Pineapple Enterprises Corporation. And or if we decide to hold the property, we'll just all be board of directors and have placements and roles and positions, and then we'll just, have either the property LLC owned by the disregarded LLC, the holdings company, and then if we decide to hold and manage some of the properties that are here.
So-
I know that Charles has some properties. So this is all kind of like proof of concept, just going over different basic ideas. At the end of the day, like a little bit about me and my background on some of this stuff, and is like and I have clarity of what I'm doing and how I'm doing it. And then in January, I hired 2 virtual assistants, and then and then I got I had to lay those 2 assistants off, and then February I only had 1 virtual assistant, and I got the same outcome in the results. I think they did about $2,000 to $3,000 or 1,000 phone calls, and we got 4 appointments. And they average about 100 calls a day. Now I have a Mojo dialer with 1 assistant, but 2, she's kind of been sick. And then now we're getting about 400 to 500 phone calls a day and more responses. So, how does this all make sense to you guys? Is, with that, I can pull a list and we can make phone calls for the Louisiana area and build rapport and try to find some homeowners who are interested in selling their house or who are behind on payments and they need us to assist with them in either helping them save it or selling it. And so when we go that route, then we can sell them when they want to sell it. We can do multiple different things, figure out what's a win-win for them. We can wholesale it, we can buy and hold it. We can take over the payments, and then we could put have Charles manage it with some of the women programs that we have going on. And so those are the different strategies of what we can do and how we can do it. So hope that makes sense. You know, just seeing the numbers increase and just seeing the more activity, and it makes sense, and it's more comfortable for me now. It's a lot of work. I can't do all the work for myself, but I can do most of it. And then, you know, obviously we're all here together. We can analyze it, put it together. We can wholesale it and then put that into like one of our LLCs. So again, either flipping, buy and holding, whatever the options are, possibilities are. There's a bunch of different various ways of doing it. I do understand where he's coming from, and then I understand, you know, there's ways to go around it, and then, you know, but it's all great seeing you guys. I can get another one on board if you guys have more questions. But I do have a homeowners meeting in an hour, so I still have to shower, change, and then get out of here. So I hope that was informative and helpful for you guys. And then I shared the PDF for sale for with Rini. If Rini can email it out to everyone.
I can email it out to everyone.
It's a link. It's a link.
It's a PDF.
It's a PDF. I can email
No,
it.
it's a link. It's a link to the PDF.
No, it's a PDF that he emailed it to me, and I'll send to all of you. It's an attachment.
Just an
So
attachment.
I will email it to you. And I think next, Jimmy, if you don't mind, next Monday you could go over the numbers with that spreadsheet. I mean, we all can review it prior, and then if we have any questions, you know, as far as experience, I've had all of these structure that were mentioned, tenant income and the whole thing. I've done every single one of them in my life. So I'm familiar with a lot of that stuff.
Is that house still available? Is that house still available? What is it called? The street is still
Sales
available?
Street.
I gotta go. Love you guys. I'll talk to you guys later.
Bye.
Okay, thank you, everyone. Bye.